So we start off at a stage when some states, some areas of states are reopening, in part, some more than others, and still other states not reopening. So different businesses and different industries are facing special challenges. And at this point, workers are returning who have been teleworking. Maybe they were furloughed, maybe they had been laid off permanently, fired. And employers are now, especially after PPP funds have been made available to some in the first and now the second round, are feverishly trying to solve really unprecedented legal and logistical challenges to strike the best balance between saving lives and saving businesses. Complying with the myriad of employment law rules and regulations was very complicated before the pandemic. Now it's exponentially more daunting. So we want to present some pitfalls and tips to follow for employers as they cautiously transition. Safety is job one. Employers have a legal obligation to maintain a safe work environment. And at this point, it's more important than ever to follow and monitor the federal, state, and local governmental directives, guidelines, and recommendations. You have to be up on them on a daily basis. OSHA has a general duty clause that we'll look at in a second that must be complied with from a regulatory point of view. Private lawsuits have already started to be filed against meat packing plants. Emergency injunctions have been sought to mandate immediate compliance with the OSHA rules and CDC guidelines for safety. Employees will be filing a massive wave, surely, of workers' compensation claims if they should become ill on the job, especially if they're considered necessary workers, essential workers. Workers will need all of their ingenuity, employers will need all of their ingenuity to make sure that there's testing in place, screening, denying access to employees with symptoms, supplying protective equipment, refitting workstations, stagger schedules, consider a 4-day work week instead of 5, consider using Saturdays to keep the number of workers interacting at a lower level, continue some or a large or complete form of teleworking, consider permitting the returns to work to be voluntary so that you're not forcing people to come back who might not want to or be able to for some reasons. Try to limit workplace occupancy levels, spread things out, put some rules and procedures in place, and try to disinfect workplace environments. The OSHA General Duty Clause provides that the employer must furnish a workplace free from recognized hazards that are causing or likely to cause death or serious harm. And the rulings lately have been that being exposed to the pandemic is one such harm that could be imposed on an employee coming back. So the General Duty Clause violation can be shown if the employer fails to keep the workplace free from a hazard to which the employees are exposed, the hazard was recognized, the hazard was causing or was likely to cause death or serious physical harm, or there was a feasible or useful method to correct the hazard. Do you think what you've learned about the meatpacking plants would fall under this regulation? Yeah, I think so. A private suit was filed just yesterday. An article came out, a judge dismissed a Missouri lawsuit over meat worker safety, where the judge basically said there's no private cause of action for an employee to sue for enforcement of the OSHA rule, general duty rule, but administratively, OSHA itself can pursue an administrative claim against a particular employer. Question has arisen, are essential workers entitled to workers' compensation? And this is driven by every state. There's no federal rule on this. And the states, right now, there's no clear answer. Some states have weighed in and some states haven't. Illinois had imposed a rule that said that there was a presumption that someone who went back to work and got COVID-19 was presumed to have gotten it at work. And they had to, a lawsuit was filed to get Illinois to back off that immediate rule. They did withdraw the rule, but they're going to pursue that kind of a presumption by following regular procedures to enact those kinds of provisions. So, how does the government encourage people to go back to work, and how the workers, employers are going to ask workers to come back to work, and if they refuse to come back, they're entitled to fire them unless they have some excuse for not coming back. But when they come back, what if the employer doesn't provide a safe environment, and then the worker gets sick at work and files for workers' comp and can't get compensated, or dies and there's no death benefit for the family? So there are a lot of issues involved. One area to consider right away is anticipating the onslaught of a myriad of employee claims. So employers should immediately secure employment practices liability insurance, EPLI, if you don't already have such insurance. They should actually consider filing a lawsuit against their carrier if claims the employers bring for business interruption damages under their commercial property all risk insurance policies are denied. So speak to your brokers, speak to your counsel to see if there's a basis for such a suit. I've had experience dealing with suits against insurance brokers who did not adequately explain what the whole concept of business interruption insurance was, and the concept of self-insurance. Many employers think that, well, you may be out of business for 3 months or 6 months, so I'll get 4 months worth of coverage based on the revenue stream. Well, when you secure an amount that represents 4 months of your annual compensation, you're basically insuring yourself for 1/3 of what the risk, what the loss may be. So if you're out for 3 months, you don't get 3 months worth of lost revenue. You would get 1/3 of that amount. So you have to be very careful and look at your policies very closely. And that's why insurance brokers may be liable if they didn't give adequate information to their clients. Romeo is going to spend a good deal of time dealing with forgiveness under the PPP, so I'm going to pass on that subject right now. In addition to other kinds of claims, there's going to be one area that is going to have a lot of litigation, with a lot having to do with overtime and minimum wage claims. A lot of employees are working from home, they're teleworking, they're not working in the same typical environment. The employer always has the obligation to keep track of hours worked by non-exempt workers to determine overtime to make sure minimum wage is actually paid. So employers are going to have to do whatever they can to devise whatever procedures or use whatever technology is in place to make sure that employees keep track of their time. Many employers are concerned that employees are home and they're getting interrupted by all kinds of things that interrupt us at home that don't affect us at the workplace. And employers have to rely on employees to be accurate and correct and honest about how they're working. One area in particular deals with meal breaks. Generally speaking, sometimes people refer to it as lunch break, but it doesn't have to be lunch. It's a bona fide meal period where you can be off the clock and you don't have to be paid, but generally it's got to be around 30 minutes. Doesn't have to be exactly 30 minutes, but about 30 minutes, uninterrupted, private time. The employee can't be interrupted, phone calls and requests to get this and get that. So if someone's working from home, sometimes it's hard to figure out exactly when the employee should be off the clock. Some employers make the mistake of saying, they tell all their employees, you're allowed 30 minutes for lunch. And then they come in at 9 and leave at 5, and the employer takes off 30 minutes automatically from 12 to 12:30. Any plaintiff's lawyer or any Department of Labor person who looks at that will understand that it's inherently inaccurate and incorrect and could lead to a claim on behalf of lots of employees in a collective action for all of the 30 minutes someone's taken off the clock automatically, all at the same time from 12 to 12:30, let's say. And you can go back 2 years, sometimes 3 years, and it gets doubled automatically unless the employer can show good faith and reliance upon some kind of formal opinion or a letter opinion from the Department of Labor. So it could be a massive exposure. So you gotta be careful how you deal with lunch, a meal break. Employees who are paid minimum wage, but now because they're working from home have to buy their own equipment, their effective wage rate may be less than the minimum wage rate because they were at minimum wage, they spent money of their own, and now they're under, and there could be exposure. If employers are going to conduct some checks on employees before they leave, and then you're taking off protective gear and getting out of work clothes to go home in fresh clothes, etc. The time spent may be compensable, so you got to be careful about that. There are exempt employees who, during a pandemic like we're having, or after a hurricane, start performing a lot of non-exempt duties, and they may lose their exempt status, and they may be entitled to overtime, and therefore you need to make sure that you stay on top of what their duties are and see whether they should be reclassified as being exempt or non-exempt, and keep track of time and pay overtime. At some point, if they go back to their old duties, document it, show in the job description that they're performing exempt duties and therefore don't qualify for overtime any longer. Obviously, when someone was exempt and then became non-exempt and exempt again, there's going to be some fact issues as to when was that exact moment that they really went back to the other classification. So you have to be careful. One thing an employer can do is have a policy that tells employees in teleworking or otherwise, you're forbidden to work overtime unless you get prior written authorization. A lot of companies think that that's the end all and the be all to the issue. It's not. It's not. It's a policy. If the employee works overtime without getting prior authorization, the employee must be paid the overtime, even though the policy said they're not allowed to. They must be paid. But if it turns out that, the after the employee violates the policy, the employer can discipline the employee and inform the employee that if they violate the rule again, they're subject to discipline, including potentially being terminated. Technically, under the new Families First Coronavirus Response Act, the second statute that was passed, an employer who violates the act by not giving paid leave to employees who qualify for it under certain circumstances, generally either because they're sick, they're caring for someone who's sick, or they're caring for a child who's back home from school and they cannot telework. They're entitled to certain amounts of leave, paid leave. If they're not paid, an employee can file a lawsuit under the FLSA for what they're referring to as a minimum wage violation. And another area in this area has to do with highly compensated employees who may have been over the limit, may have had their salary be high enough to be exempt, but then all of a sudden, if they're cut back on their rate, it may be that they fall below that figure, and therefore, at that point, they may not be exempt any longer. The next area has to do with whistleblower and retaliation claims. I think it would be an understatement if I stated that there's so many new rules, regulations, laws, and requirements, and there's such uncertainty about how to do it and how to do it correctly, when to do it, etc., that there are going to be a lot of employees who are going to be complaining. And they're going to be complaining about their employers violating a law, rule, or regulation. And any employee who thereafter becomes the object of any kind of adverse employment action, gets fired, demoted, pay decrease, etc., that employee may claim that they're a whistleblower because they complained to the employer, and as a direct result, this negative action took place against them, if that was the case. Under Florida statute 448.101, that employee can file a whistleblower claim. And if the employee was terminated and couldn't get another job for a year, the employer could be on the hook for a year's worth of compensation if the employee could prove that claim. So before you take action of a negative nature against an employee, one item on the mental checklist is, did this employee make any complaints about any subject dealing with the company violating a law, rule, or regulation? The same could apply if there was a FMLA, Family Medical Leave Act claim, an employee who feels that their rights were neglected, or they were retaliated against because they filed such a claim for leave. This is the regular FMLA for unpaid leave, and their job wasn't available when they wanted to come back. There could be a claim for retaliation there as well. And there are other areas where retaliation could kick in. Someone complains for workers' comp, they complain for overtime, they complain in a Title VII discrimination kind of a claim. There are many ways in which an employee could file a retaliation claim. So before you axe somebody, terminate someone, or take negative action, you want to be careful that you haven't, the person hasn't objected. If they have objected, that you're firing them for a reason completely unrelated to the fact that they made an objection. A few weeks ago, an Amazon employee was protesting against Amazon's alleged failure to have a safe work environment, and held up a sign and got fired. And it turns out that under the National Labor Relations Act, employees are allowed to complain about work conditions, and they're allowed to complain to other workers about work conditions. And that right is protected because it might lead to a unionization, et cetera. And as a result, an employer could unwittingly get itself sued for retaliation by firing or taking negative action against employees who speak out negatively against the company. Another area that is of concern is under claims that employees may file, or strangers to the company may file, under the False Claims Act, known as key TAM lawsuits. The key TAM False Claims Act lawsuits originated with during the Civil War. Abraham Lincoln was upset that too many people were ripping off the government and government contracts, and the statute was passed. And basically, in its simplest terms, if you steal money from the government, or if you fail to pay the government money you should be paying the government, either by contract or otherwise. Oftentimes we hear about it in terms of medical people overcharging on Medicare or failing to pay taxes, etc. An employee of the company or even a stranger can file a lawsuit under the False Claims Act and claim that this occurred. It's sort of a private derivative lawsuit. Instead of a shareholder's derivative, it's like a private citizen derivative lawsuit. The government can decide to take over prosecution of the suit within 60 days or at any point. So oftentimes when that happens, the government has great resources available to it. It can go against that contracting party or company and really put the hammer to them. In which case the employee who filed the suit, depending on whether the government takes it over or not, can get 15 to 30% in that range of the recovery, which could be millions of dollars, and attorney's fees to the attorney. So companies want to be sure to be in compliance with those kinds of legal obligations involving the government and investigate any complaints or irregularities. Can anybody here imagine, with the rush and the craziness that took place, that there might have been some employers who gave wrong, incomplete, or false information to the government to qualify for the amount of PPP loan they got, or in the process of trying to have the loan forgiven and be turned into a grant, might do the same? And there might be employees or others who might rat them out to the government, in effect. That was a bad choice of words. File a complaint against the company. There are going to be a lot of these kinds of lawsuits. So be in compliance, and if someone complains, fully investigate, and just be sure that you're not taking action that's going to upset somebody who files such a claim. If businesses are now rehiring employees, there's going to be some potential bias there could be some potential bias in the rehiring process, especially in a situation where sometimes even good intentions can lead to trouble, where an employer might decide, you know what, let me be a good employer. I'm not hiring everyone back. I'm only going to hire half the employees back, but I'm not going to hire any older employees. Okay, and because older employees, I'm told, might be more susceptible to getting the virus and spreading it, or dying from being exposed. So I'm not going to hire any older employees. Well, you may unwittingly be exposing yourself to a suit for age discrimination. Some employers may say, I'm not going to hire anyone who's pregnant. There may be some gender discrimination. Or the employee is perceived to have some kind of pre-existing condition that might make them more vulnerable. It may be an ADA, a disability discrimination claim. So it's a little bit of you're damned if you do and damned if you don't. So you're going to have to be very careful as an employer, basically to avoid getting sued for bias in hiring employees back. One way to deal with it is, if you can, make it voluntary. Try to find out who's willing to come back voluntarily. And if it turns out that a disproportionate number of older workers or workers with conditions more susceptible that don't volunteer, then that may be one way to handle it and avoid a potential claim. There'll be another situation where there might be some people who took the benefit of the leave payments under the Family First Act, where they were sick or caring for someone or stayed home with a child. If an employer wanted to be vengeful, the employer might say, I'm not going to hire any of them back. I'm just going to hire back the people who didn't make those claims. That actually might be a violation of the anti-retaliation provisions under the statute. So you have to be careful about that. Another area, and as far as that's concerned, if you're going to test employees before allowing them back, the EEOC has made it known as an opinion that companies can test for the COVID-19 before permitting employees to re-enter the workplace, as long as the tests are accurate and reliable. And you can take temperatures, and doing so would not be a violation of the Americans with Disabilities Act under these extreme circumstances. Normally, you can't do mandatory pre-testing unless it's job-related and it's consistent with business necessity. And basically applying that standard, the tests are being allowed because otherwise the virus poses such a direct threat that not to test would be unreasonable. As these testing methods are being used and we start doing contact tracing and other immune identifying techniques, more discrimination claims may occur. Again, particularly with some individuals who've previously tested positive or are currently positive. If you're currently positive, employers can keep those employees away. If someone was positive but no longer has the symptoms, it may be that those employees are more able to return back to work. They be welcomed accordingly. It's believed that if, with the states opening up, there's a concern that there'll be a second wave of employees getting the virus. And in the fall, when it's flu season, the effect may be worse than we've already experienced. As a result of the WARN Act, the federal statute that requires employers with 100 or more employees to give it at least 60 days notice comes into play. And failure to give notice may result in liability to the employer. So larger companies that have a sufficient number of employees have to give 60 days advance notice, and they have to give information, demographic information about the employees who are being let go. And a lot of employers fail to comply with the WARN Act, and a lot of them will be getting sued in months to come. Unemployment issues. Some people out on unemployment are getting more than by staying out and not coming back to work than they would if they came back to work, especially with the $600 per week amount involved. That's going to run out, I think it's July 13th or July 30th, I don't remember the date. In any event, it may be extended, may not be extended, so employers may have trouble actually getting workers to come back. Some employers are trying to pay them more than they had been paid before, at least equal to what they're getting on unemployment if they really need them back. So that's something that employers can consider. And what employers need to do is be careful. When someone applies for unemployment and the employer is asked to give its input, the employer should be careful as to how they respond, because if the comment is, we let this person go because they contracted the virus, that's retaliation and the employer could be exposed. you have to be careful. If the answer is we let this employee go because of the effect of the pandemic on the business, then there'll be certain tax benefits actually that the employer could get under those circumstances. And I misspoke. Basically, the unemployment claim won't be charged against the account of that employer. The next area that Romeo can speak more and better about has to do with re-onboarding correctly. If you've terminated an employee and then 2 weeks later, 4 weeks later, 2 months later, you hire the employee back, you should re-onboard the employee fully and correctly because you may need to have the employee, you will have to have the employee re-enroll in all the insurance benefit plans, re-sign employee handbooks, arbitration agreements, etc. So I'm going to try to speed up a little bit and make sure I get through everything I'm going to talk about. The Family Medical Leave Act, if the employee is believed to have a serious health condition, the employer must reach out to the employee and provide the paperwork to see if they qualify. Under the ADA, if the employee has a disability or is perceived to have a disability, the employer has a duty to engage in the interactive process to determine if the employee qualifies for a reasonable accommodation. The employer can't just sit back and hide under a rock and say, well, bury the employer's head in the proverbial sand and say, the employee never told me. The employer has obligations to affirmatively reach out. Potential brave new world we may be facing a situation similar to what was implemented in areas of China, where color-coded QR codes were issued to individual people who had been tested and can prove and certify that they're disease-free or that maybe they have antibodies that will protect them. And it may be that when we have a full return to a full workforce, if the virus is around for 2, 3, or 4 years, as some people are saying it could very well be, we may have to resort to such a system, which is going to create all kinds of issues and problems. And here's some current photos from what employee life in China looks like. Taking temperature, distance, QR coding, etc. Who controls the information? Are we remaining HIPAA compliant by protecting health information? Very careful. We have to be very careful about that. Employers are pushing for statutory immunity. There has to be Congress and state legislatures to pass laws protecting the employer, so the employer won't get sued. And the question as to whether that's really going to happen or not, or is the burden going to remain on employers? Many clients have contacted me and asked me to prepare for them some form of acknowledgement, waiver of liability, release, covenant not to sue, assumption of risk, and indemnity agreement relating to the virus. Generally speaking, it's questionable because if OSHA and other state and federal laws and regulations put an obligation on the employer to have a safe environment, can you really have employees sign away their right to be safe at work? So it's highly questionable, but erring on the side of judgment, a lot of employers are having employees sign acknowledgements. I know there's no perfect situation. I'm assuming the risk. I accept that the employer has done what's reasonably appropriate to provide a safe environment. I'm not sick. If I get sick, I'll let you know, et cetera, et cetera. But generally speaking, there won't be enough judges, attorneys, juries, administrators available to deal with the potential explosion of anticipated litigation. So basically, now more than ever, employers are going to have to rely on their entrepreneurial skills and financial wherewithal to strike the right balance between personal health and safety and life and having the business continue. Hopefully, remdesivir will be a drug that will be shown that can be used for treatment. Hopefully, the vaccine comes in quickly. We have to keep praying and hope that happens. Thank you for listening. There's my information. This will be posted on my firm website, and you can access it and call me with and email me with any questions that you have. I've rushed through this. I want to make sure I leave enough time for Romeo. Thank you for listening. I'm going to release the screen, and we'll now have the benefit of listening to Romeo and you all learning about what you really came here to learn about. Romeo, I hand it off to you. You have to unmute. There you go. There you go.
All right. Thank you. And I think you need to allow my screen sharing as well.
Yes. You got it.
There we go.
Thank you.
All right. So this next half, we're going to talk about the forgiveness of the PPP loan. I've fielded a lot of questions from companies, and there just seems to be a lot of bad information or maybe just untimely information. This is something that is changing literally daily. As I've been putting this presentation together, since Friday, I've had to go back into it and make 3 revisions based on the SBA coming out with new guidance on the 3rd, the 5th, and the 6th of this month. So I had in here, the information is subject to change. It will quite possibly change, or will most likely change, I should say. But now that you have these funds, there are some decisions to make what you are going to be doing with them. And I think I've summarized it into these 3 categories. Either your employees are already working, maybe they're reduced hours, but your staff is there, and now you have the funds to bring them up to full-time status again and pay them. Rehire your workforce. So if you were shut down or there was no work, you laid them all off. And I break this down into, I think, 2 categories. In South Florida, we're still under a government shutdown. Other parts of Florida, we're allowed to reopen in phases. So if you're in one of those places where it's being lifted, you're coming back in phases, then you're going to hire your employees back, hire them back at full force. That's what the government wants you to do. So when business is here, your workforce is ready. But there is the possibility that you hire everyone back, you spend this money, and in 8 weeks, there is no more money and there's no more work. And you quite possibly will have to lay off the employees again. And if they weren't happy the first time, they're not going to be happy the second time going through the state unemployment system and reapplying for state unemployment. I know firsthand of people that are still 5-6 weeks out after filing and still not have gotten any funds. So and the unemployment system is not fun. And then the third thing, which talking to some companies, is not hiring employees back, holding the funds and using it for other purposes. Hey, I have a business. I may need this for rent. I may need this for other things when I'm able to open 3 months from now or 4 months from now. This is a long-term process. With those considerations in mind, I want to point out that when you signed your loan documents, there's quite a few things in there, but there were 2 certifications that you made. One is you saying you got the loan and it was necessary for your ongoing operations. The second one, or it's actually the third certification you made, is that you are taking the funds and you agreed that you are going to retain workers, maintain payroll, and if you don't use it for those purposes, you can be held liable and charged with fraud. So going back to those conditions, if you're thinking of holding on to this funds and using it for other things, that may be very bad. Recently, the SBA came out with this statement saying if you use these funds for unauthorized purposes, they are going to quite possibly subject you to committing fraud. You took the money, you're using it for now some other purpose than it was intended. And they're looking to go after anyone involved in that process. So not necessarily just the person that signed the loan agreement. So if that was your intent and you are sitting on this money, the SBA just put out yesterday, actually up until yesterday, I think it was earlier last week, they said you had until May 7th to give the money back. Yesterday they came out and they made it now May 14th. So if you have the funds and you realize this was a mistake and you really don't deserve it, you have until the 14th to give those funds back to your bank and kind of wash your hands with it. And that will open you up to other things. So there's the employee retention credit that you're not allowed to do if you've got the PPP loan. So now you can go and get the employee retention credit. They said we'll allow you to do that even though you did initially get the loan. All right, so now if your decision is, all right, I'm going to take the funds and I'm going to use them for an intended purpose, the first thing to do is determine your deadline. There was some misinformation out there that, if I got my money on April 30th, 2 months out is June 30th. That is not the case. It is 8 weeks. I am not quite sure how they count 8 weeks. Does it start, do you count the next day as one after you get the funds or the day? So my rule is, figure out 8 weeks from the day you got the funds, subtract 1 day, and you should be safe. And that is your deadline. And we'll talk about what that means in a moment here. What you can spend the money on is very specific. It's broken down into non-payroll costs and payroll costs. Payroll costs are what you see on the screen. It is rent, interest on any debt or mortgages. I did research for someone just yesterday. If you have a business automobile, so if you have a delivery truck, or if you have a limousine service and you have a limo, and those are company vehicles. So the interest on that payment. And then there are utilities, electric, gas, water, phone, internet. I am not clear about cell phone. I have not found concrete evidence to say whether it is included or not. So I think if you can get enough expenses with everything else, then don't risk it and try to force cell phone in there. There is transportation utility fees, and I don't want to give the full definition of that. If you know what it is, you can use it. If you don't know what that is, it probably doesn't apply to you. It's very specific. Any of these items on here need to have been in existence prior to February 15th. So if you are just hooking up new internet access on March 1st, that does not appear to be eligible. There is some question of, my business lease ran out on April, we'll say April 1st, and I had to sign a new lease for my property. That is a questionable area. We think it's going to be okay if you're just re-signing an existing lease. So that appears to be okay, but the existence of the initial has to be before February 15th. Payroll costs is pretty much everything that's payroll that you pay your employees. Wages, salaries, commission, holiday, bonuses, severance. It's pretty much every gross expense, and we'll go through some exclusions in a moment. There are a couple of other expenses. So the employer cost of health insurance, the employer cost or contribution to an employee's retirement plan. So your 401k, 403b, your contribution is a payroll cost. And the only tax that you're allowed to count as payroll costs is any tax you pay to a state or local government. So in essence, state unemployment taxes is it. All the other tax, your employer taxes, you are not reimbursed, or that is not a forgivable expense. There are some exclusions to payroll costs. And I'm kind of looking at the chat every now and then, and I'll try to fill some of these in. This answers one of the questions. There is a compensation limit of $100,000 per individual. And the way we calculate that is it's an annualized 100,000. So over the course of 8 weeks, we're saying that's 15,385. Benefits for owners also appears to be excluded. So if the owner is contributing to a 401k and there's a matching on it, we don't believe that that match on the owner's contribution is included. That would be excluded. And it kind of makes sense because it's just the owner taking more money for themselves. So they're limiting to 15,385. It also excludes people who don't live in the US. Wages paid under the FFCRA Act. So you are already getting a credit for that, so it's really not your payroll expense to begin with. As well as reimbursements, non-taxable reimbursements to employees. That's not a wage you pay them, nor are independent contractors payments. They could have gotten their own PPP loan or their own loans out there for that.
Doesn't matter.
Someone asked about fees paid for our service. That is not a payroll cost, so there's no payroll fees. It's just what we saw on those last 2 slides of what's included or excluded. Now, how you use the funds is very important, and you cannot spend more than 25% on non-payroll. You have to spend at least 75% on payroll. Anything more than 25 or anything less than 75 on the payroll reduces your forgiven amount. And being that we're doing this presentation, I'm trying to talk to as many people about planning. So the best way to plan is no more than 25% on non-payroll. I'd say, look at your rent, look at your utilities, figure out those non-payroll costs, forecast it out, and say, okay, I'm going to spend $20,000 on that, and I have a $100,000 loan. That means I have another $5,000 that if I don't spend on payroll, it's going to be owed back to the government. So plan, figure out that 25%, what your non-payroll is, because those are somewhat fixed costs. Your rent and utilities, you kind of stuck with what that is, but payroll, you can pay a little more to people. I've heard some people paying return bonuses for the ones that are coming back now. They're giving them a little extra. You can do that. All right, so now that we know how much to pay, another condition of the loan forgiveness is who you are paying it to. The whole title of it, Paycheck Protection, is the intent is to pay your employees. You are really taking the place of unemployment. They're giving you a little extra for rent and utilities because those people have to have some place to work. But the intent is to protect the paychecks. They want you to bring back 100% of your workforce that you had pre-COVID-19. They give you 2 look-back periods. And we'll talk about counting in a moment, but you look at these 2 periods of time, find out how many employees you had in those periods, and that's what you need to have now. They say if you're seasonal, you can use the 2019 period. But you can use either. I say, you know, look at both, maybe find out which one is less, because then you have a lower target to go for. Now, the big question is, how do we count this full-time equivalent? There is not really guidance. I've, again, seen a lot of bad information. This is how I count, and it may come down to that. If you can substantiate how you count, that, you know, that could be it, but we are expecting some further guidance on this. I say, when you look at your employees, if you have someone who's salaried, you count them as one. Take them out of your mix. They're a whole employee. There are some exceptions. So I know we have a company that has 4 related companies, and they get a salaried person gets a little 25% of their pay from each of 4 companies. So in that event, you can count that salaried person as a quarter. But most times you have a 1 company, that's a 1. The next thing is, look at your total number of employees for a pay period. Eliminate overtime from that, because you can't have someone who counts more than 1. And overtime would give you a count greater than 1 for an individual. So take the overtime out, and then divide that total by 40 hours for however many weeks are in that mix. So in my example, I'm saying I have 2 salaried employees, and I have 13 people that were paid 842 hours, excluding overtime. It's biweekly, so I take 842 divided by 80. That gives me about 10.5 people. You can't have a half person working for you, so it has to round up. So we get 11, plus our 2 salaried. We get 13 full-time equivalent, even though I had 15 physical bodies in my office. Right. So now, bringing back your employees, many of you are faced with that, all right, we've got this money, we're starting to reopen, and I need to bring my employees back. This was an interesting article I found a couple of weeks ago. It was certainly expected. You know, you call your employee who may be out there collecting unemployment. In the state of Florida, even a part-time employee can very well be making $875 a week on unemployment. That quite possibly is more than you were paying them for working. So when this business owner went out, held a company meeting and said, great news, we got money, there's some comments, you know, it was a firestorm of hatred. You know, how could you do this to us? The business owner said, it's going to take years for me to kind of get past all the negativity that's coming from my employees, because I just cut their money. So that is something you will face. Again, just recently, the SBA came out with this. And again, the reason is they want the business owner to take place of unemployment. The Treasury said it in a press conference a few weeks ago. Every dollar I give to you on the PPP is a dollar we're not sending out in unemployment. So this was put out. If you make a written offer to an employee or a separated employee, someone is terminated, you say, we are hiring you back. And the employee says, no, thank you. You document that. You don't necessarily need anything back in writing, but if you have it, great. Document it. That person comes off of your list of having to recover that body. So if you had to have 13 full-time equivalent people and this full-time person says no, you only have to have 12. What I believe is going to happen is, on your forgiveness application, you're going to have to document these employees probably give their social security number of who you made an offer to. And I'm almost certain they're going to then match that up with unemployment, go back and say, God, John Smith, you refused a job offer on May 6th. We see we paid you unemployment through July. Well, now you have to pay all that money back. So that is an interesting twist that they put out. Now, if you do not meet the full-time equivalent, so you just say, hey, I'm not going to hire these people back. I only need 5 of my 10 employees. Then there is a direct proration of non-forgiven loan based on that percentage. So in my example here, I say if you had 10 in your pre-COVID count, and you only bring back 9 and you didn't make that offer to that 10th person and they rejected it, then you had a 10% reduction in staff. And right off the top, if you got a $100,000 loan, that is $10,000 that is not forgiven, regardless of any other thing you may have done right. There is another condition that says, all right, hey, I've brought back my employees and I'm bringing back everybody full time, but I'm going to cut their rates down. I'm going to decrease their salary, decrease their hourly rate. That is perfectly fine. Just be careful. Don't decrease anyone below minimum wage. That's bad. Now they did give you a cushion. You're allowed to reduce someone's pay by 25% compared to the first quarter. Now, hopefully you didn't issue a whole bunch of big bonuses in the first quarter, because then you may have that to deal with. And I'm not quite sure how that would work out, but the comparison is to first quarter. And I'm going to do some math on the next page. So the math is, I paid someone $20,000 in the first quarter. You have to annualize it. So I come up with $80,000. During the 8 weeks of the loan proceeds, I'm giving the person $1,000 a week, and I've paid the person $8,000. You then annualize that. So now I've annualized $52,000 is what I paid that person. So now we're dealing with apples and apples. I can compare 80,000 to 52. That is a 35% reduction. I went below the 25% limit. So 10% of that person is not forgiven. So 10% of the amount I should have paid, 80,000, is kind of coincidentally in my math, it works out to $8,000.
Mm-hmm.
So 8,000 is annualized.
It's the difference.
It's a different, yeah, just the 10%. So that 8,000 is again an annualized amount. You divide it by 52 times 8, because we'd have to bring it back down to an 8-week value. So $1,231 is not forgiven for short paying this employee. It is an interesting math. We have generated a spreadsheet to help companies with this formula. There have been questions, because if you have John Smith, who he worked in the first quarter, and now that same employee is paid through the loan, I have an equal opportunity to make this comparison. But if John doesn't come back and I hired Tom instead, a brand new employee, then who do I compare Tom to? So it's a little bit of a gray area as to, all right, do we have to say Tom took John's position and and he should have been paid at 80, but maybe he's not qualified at the same level. So this part is going to be a little tricky. And again, as soon as we have some guidance come out from SBA or Treasury, I will try to communicate that to everyone. Now, I know if you're a sports fan, I was trying to think of some terms. You know, if in basketball you throw that full court shot at the last second, or in football you throw the pass down into the end zone to try to get that last touchdown to win the game. The SBA is giving you that same opportunity here. They're saying, all right, you failed during your 8 weeks to bring back 100% of your workforce, or you failed to pay someone 100% of, or 75% of the pay. They have set June 30th as a deadline, saying, okay, forget about the 8 weeks, you didn't make it, you only hired 90% of your staff. If you bring back that one more person by June 30th, we will disregard that you failed during the 8-week period. Now it's kind of a tricky date, because if you are just getting funded for the loan now, then June 30th is within your 8-week period. So you don't get that final shot. If you got your loan back in mid-April, then it's quite possible your 8 weeks ended sometime around June 7th, June 10th, and you now have another couple of weeks in order to bring back everyone. Again, this is another one of those vague areas. You know, we don't think you can hire someone on June 29th and then fire them on July 1st, that would count. So there may be some sort of longevity in that process, but they're just using that single date. Meet it by June 30th and we will forgive that we held it against you in the first place. A couple of bonus pieces of information. Pay everything with a check. Don't use a credit card. That may not be seen as paid. You know, you're just moving it to a credit card. This is cash-based accounting from everything that I read. That means, you know, if you have a 401k and the employer contribution is deductible, it's when those funds go to the pension company. It's not when you ran a payroll and created the liability. It's when you pay your electric bill, when you pay your rent. I've seen, when it comes to rent, I've seen some advice out there saying prepaid is not allowed. I cannot find any evidence in any of the act or further documentation that says it's not. So that would tell me, you know, if your loan ends on June 29th, pay your July rent on June 29th. That seems to be perfectly fine according to the way it's written out there. Oops. The forgiveness process, a little bit quick on that, is this is going to go back through your lender that gave the loan. You know, document everything. They're probably going to want to see invoices, possibly lease agreements, maybe even canceled checks, payroll registers. There's again going to be a certification process in there where you're saying, yep, these are true documents I'm giving you. Another piece that came up recently is, with all of this bad press, SBA has come out and said we are going to look at any loan that was over $2 million. If it's below that, it appears to be just between you and your bank. But they did put in the language, other loans as appropriate. So if they get a whistleblower, SBA may come in and review what has transpired on that. The IRS has their hand in this. Normally, when you have debt that's forgiven, it is taxable. So if you owe someone money and and they go, oh, you don't owe that anymore. That is now income to you in essence. This PPP loan is excluded from that. Forgiveness of the loan is not taxable income. But this was interesting. On just last week, the IRS came out and said, but you know what? The expenses that you paid, all that payroll and your rent, you can't use that as a deduction from your income for tax purposes. So that posted, we've seen a lot come out of Washington saying, wait, no, that was not our intent. Our intent is that this does not create a tax event anywhere. You know, the loan being forgiven is not taxable, and a business can still use the deductions that they paid for the forgiven part as deductions off of their income. So this is still a live conversation. I usually see Congress winning on this over the IRS and saying, you know, that was our intent, and to remove what they put out in their IRS notice. When I share this presentation, I do have a lot of hyperlinks in here, so you're able to go back and click on these. If you do get stuck with a non-forgiven amount, you know, you did make an attempt, anything that's non-forgiven, you can pay back right then if you want to just close it out. Otherwise, it's a 2-year term, 1% interest. There's no payment for 6 months. So in your 7th month, you can start paying on this. And again, I'll provide this as this presentation out there. I've got a link to the frequently asked questions. The Treasury seems to update this almost daily. So 3 times in the last 5 days, they've updated the frequently asked questions. I also put my website on there with just specific COVID-related information. We will post the presentation there. And I also have on blog.paymaster.com, the most recent article. I have a calculator that's in there where you can put in your 1st quarter wages and 8-week wages, and the system is going to calculate the percentage and what is not forgivable. So you can use that if you're looking at underpaying somebody.